If it pleases the court, my name is Catherine Higgins, spelt Higgins, and I appear for the defendant, Mr. Leonardo Vella, born 23rd of June 1989, and he is 27 years old. Your Honour, my client has been charged under the Drugs, Poisons and Controlled Substances Act 1981 to state law, Section 73, with the possession of 4.25 grams of heroin, and that charge occurred on the 1st of July 2017. I have been instructed by my client to accept the charge and enter on behalf of my client a plea of guilty. I'm aware that this conviction can lead to a maximum of 1 year on the balance of probability that the court finds that the offence was not committed by the purpose for any purpose relating to trafficking. Before I begin, however, I would firstly like to hand Your Honour a reference for Mr. Davin Albuquerque of the Titans Soccer Club, where my client is an active member and volunteers. Your Honour, the prosecution has already seen the reference and I've provided them with a copy beforehand. This reference was dated 1 week ago. I'd like to tender this evidence before you. Your Honour, firstly, I'd like to suggest that Your Honour considers that my client is more suited to something other than a full penalty, as suggested by my learned friend of the Crown, who's suggesting a more harsh penalty. Firstly, if Your Honour would permit, I'd like to run him through the events of the evening that has led to this conviction. Does Your Honour give me permission to do so? Your Honour, my client has informed me on the night of the 1st of August 2017 at around 11 p.m, the defendant was driving his girlfriend, Lavina Lahuru, home after an evening at a restaurant in Brighton. My client was stopped for a random breath test, of which he complied. During the test, Senior Constable Daniel Smith asked to search the car, of which my client then agreed again, and it was at this point that the heroin was found. Your Honour, at all times my client obeyed the instructions, and I know at the time he might have seemed a little agitated, as anyone would have been. He complied with the instructions. Though I know initially he said he took the raps for his girlfriend, my client now admits at the time he was feeling very stressed and anxious about being in front of the police and in finding the drugs. Your Honour, my client was not trafficking the drugs, but the drugs was for the purpose of his own use. This was the first time he'd ever used the drug, and it would be the last, as you'll see in my submissions later. Your Honour, I'd like to point out the following with regards to my client. My client is employed full-time and works in the family business as a fruit merchant. He's done so for many years. He works very hard and very long hours to ensure the success of his business. It's a family business, and he feels that he needs to support his family through working really hard. He is currently in a long-term de facto relationship which is stable. He has one young child from a previous relationship which he currently financially supports. My client is also a volunteer at the local sports club, as I've previously mentioned, the Titans Soccer Club. He is a positive role model there and helps to train some of the youngest soccer players. Your Honour, my client recognises that his actions were wrong, and he's expressed great remorse. He has already committed to ongoing weekly drug rehabilitation programs to ensure that he is off the drugs for good. This is an active step that he imposed by himself on his own free will. Importantly, Your Honour, my client has also pleaded guilty at the first available opportunity due to his remorse. He identifies that he's done the wrong thing. Your Honour, my client had a rough childhood. He'd been through a tough upbringing where his father died at a young age, leaving the fruit business to him and his brothers. Your Honour, my client was very stressed on the night of the event and was under a lot of pressure at work, which led to him firstly wanting to take the drug and trying it out, and secondly being caught with the drug. I would also like to draw Your Honour attention to the very minor criminal convictions that my client has already faced in the past, many years ago. Firstly, he was charged with intentionally causing injury after a night of heavy drinking with a bunch of friends. He was only 15 at the time. Your Honour, my client was very young and impressionable at the time. He was given 100 hours of community-based service, of which he completed within 6 months at a local soup kitchen. Since that time, my client has also continued to work at the kitchen on his own free will, demonstrating that he likes to be in the community and he's an active community member. Secondly, my client was charged over 11 years ago with the possession of cannabis as a young 14-year-old after his father died. He was given a 2-year good behaviour bond and fined 10 penalty units. Your Honour, my client obeyed the good behaviour bond and paid the units in full at the first available date. You can tell that my client respects the law. Finally, Your Honour, with regards to the reference that I handed you over earlier of Davin Albuquerque of the Titan Soccer Club, Mr. Albuquerque has known the defendant for many years and personally states that my client is an outstanding citizen. He worked with him at the fruit shop and has known him since he was a child. He says that a lot of the younger soccer players at the club look up to him for guidance and support. He identifies that everyone identifies that he's showing remorse what he's done. Your Honour, I'd like to conclude by re-emphasising the positive attributes of my client and the fact that he's already shown so much remorse. He has taken active steps to never take drugs again through his rehabilitation program. I'm of the opinion that a harsh penalty would only be more detrimental for my client, especially for the local soccer community and his local business. He's hard-working, he supports his family, and he's in a relationship in which she is financially dependent. I would submit, given the evidence that Your Honour has before him, including positive character reference, that an intensive correctional option would only be detrimental to my client. I instead suggest a community-based order would be more appropriate. We've already seen in the past that he has committed to this community-based order and completed it within the time recommended. Thank you, Your Honour.